開始咯。各位委員，歡迎大家參與今日委。
Good afternoon. Welcome to the meeting of the AJLS panel. We have formed a quorum, so I would now call the meeting to order. First of all, I would like to report to you concerning information papers issued since the last meeting, and this is CB 4311/1213/01. Our Deputy Chairman has made a suggestion to the panel that this panel should look into the role played by Hong Kong legal professionals in the development of Qianhai Bay Economic Zone. I believe that is something that we should look into. So we have put this on the list of outstanding items for discussion. We will try to sort out an appropriate occasion to discuss this with the Secretariat. And also, Ms. Elizabeth KWOK has tabled a paper asking this panel to look into the way the sexual offenses are handled by the government and the courts. And this is also related to the consultation paper on rape and sexual offenses involving the lack of consent. I'll try to find a suitable location to discuss this. In the meantime, I would refer Ms. KWOK's views to the administration and ask for written information from the administration, if any, because we already held a public hearing. So this will be put on the list of outstanding items to see whether we need to convene a meeting for that. So we'll in the first place, ask for written information from the administration. Ms. KWOK. Well, I'm in no hurry. I hope we can get hold of more information so as to facilitate a better discussion. But of course, I don't want this to be put on the back burner indefinitely. All right. Let's see if we can do anything in our future meetings. We have already got the agenda set for our February meeting, and there are a few items for March already. So let's see what we can get in terms of written information from the administration. All right, please refer to the paper bracket 01, bracket 02, list of outstanding items for discussion, list of follow-up actions. The next meeting will be held on the 26th of February, a Tuesday at 4:30. 3 items have been suggested by the administration, and that is the relocation of the Court of Final Appeal to the site of former electrical building, and also implementation of projects under the Information Systems Strategic Plan of the Judiciary, and the third one is the LRC consultation paper on adverse possession. So members, do you agree that for the February meeting, we would mainly discuss these 3 items? Any other suggestions from members? If not, okay, we can allow more time for the remaining items on the agenda. First item, briefing of the CE's 2013 policy address. Table for members' information is CB4 321/1213 bracket 03 and CB4 321/12-13 bracket 04 provided by the Department of Justice and the Home Affairs Bureau respectively. In the paper, relevant information on the initiatives and policies of the 2 areas as set out in the policy address have been provided to members. Let's invite the representatives from the administration to join us now. So first of all, I would like to hand over the floor to Mr. Rimsky-Yuen, Secretary for Justice. Thank you, Chairman. The major policy direction of the DOJ and also the major areas of work for the department are the subjects of the briefing to this panel on the 16th of January. So I will not repeat every point that was made. We would uphold rule of law in Hong Kong, the judiciary independence, and safeguard our human rights. We're also going to improve and enhance our legal infrastructure. And we would adhere to this principle in taking forward the work of the Department of Justice. And this would include providing legal advice to government bureaus and departments and representing governments in court, and also to provide fair legal services, and also to enhance Hong Kong's status as a regional center for legal services and dispute resolution in Asia Pacific. To tie in with paragraph 38 and 39 in the policy address, and that is the policy to develop the professional and business services. We're going to launch a number of new initiatives in 2013 to actively promote Hong Kong as a regional center for legal services and dispute resolution. Apart from ongoing initiatives, we are also going to work on 3 areas to achieve this policy objective. First, we'll actively liaise and work with mainland authorities or departments and the legal professions and arbitration institutions in Hong Kong to facilitate Hong Kong legal and arbitration professionals to provide legal and arbitration services in Qianhai, Shenzhen, and Nansha of Guangdong. The major objective is to promote in Shanghai and Shanghai that contracts enter into for the new development area would be based on Hong Kong law, and we also to provide Hong Kong facilitate Hong Kong as a ideal place to conduct mediation and arbitration, and also to work on the measures to enable the forming of partnership between the professionals of the 2 places. We will also look at how we can provide or facilitate the liberalization for the provision of arbitration and mediation and also legal services in Shanghai. We're also going to promote arbitration through the relevant professional arbitration bodies in Hong Kong. We have provided another paper on mediation on the progress that we have made so far, as well as the way forward, the monitoring of the mediation ordinance, and the accreditation of qualification of mediators, as well as related publicity and promotion efforts. We also provide a paper to explain why we would like to establish or create a supernumerary post of Deputy Principal Government Counsel, so as to take forward the relevant work. We would like to get member support so that we can be adequately staffed to promote mediation in Hong Kong. Thirdly, we are also going to provide premises in the west wing of the former CGO to facilitate the legal arbitration and mediation institutions to develop services in Hong Kong. We are going to assess the usable floor area in CGO and also other factors and criteria to be considered in the provision of office space to the relevant organizations. We're also going to facilitate legal cooperation with other jurisdictions. In particular, we would step up legal cooperation with Guangdong Province. As I said in the opening of the legal year this year, we would like to provide a very effective and efficient modern prosecution service, and also to enhance the capability and effectiveness of our prosecution services. This forms part of our work in the coming year. A number of measures have been implemented by the prosecution service to enhance effectiveness. For example, in relation to the provision of legal advice and continue the training for the prosecutors, and also the cooperating with the two legal professional bodies to train the newly qualified lawyers. We are going to take more measures to enhance the capability of our prosecutors and our prosecution service. And also, where necessary, we'll update the statement of prosecution policy and practice code for prosecutors, so that we can better serve our clients. We're also going to identify areas of criminal law where the developments can be made, so that we can better meet the community aspirations. Lastly, we would try to enhance our ability to recover proceeds of crime. On legislation, we'll make sure that the necessary legislation for the administration can be prepared in good time, and the two versions will be easy to read and easy to use. We also, on a timely manner, certain guidelines on legislation, so as to enhance understanding of legal documents, readers of legal documents. We'll continue to introduce new editorial and amendment powers to amend and update the presentation of our laws. And there are also a number of legislative initiatives to be taken forward. For example, arbitration, the ordinance will be amended so as to implement an agreement on a reciprocal enforcement of arbitral awards entered into with the Macau SAR. We'll continue to seek improvements to the arbitration ordinance. In the latter half of 2013, we are going to present a bill on contract third-party rights, and also to implement recommendations in previous consultation. We're also going to introduce a new bill to accept instruments entered into properly by notaries in Hong Kong. We are going to come back to consult the panel. Lastly, we have set up a cross-sectorial group to consider the recommendations in the LRC's consultation paper on collective action or class action. I'll pause here. I hope the foregoing will facilitate your understanding of our work in the coming year. We're happy to take questions. Now invite Mr. Zhang Tak Sing to give his speech. Chairperson, members, from the Home Affairs Bureau, we would like to report to you the policies and initiatives on the legal aid system. The details are set out in the paper. I just want to highlight 3 points. First, on the expansion of legal aid scheme. I know quite a few members would like to have the legal aid system expanded. Just a month ago, we got the support of this council, and that is to say on the 30th of November, we have expanded the general scheme as well as the supplementary scheme. The scope has been expanded. Last month, with the approval of the Finance Committee, we have injected $100 million into the supplementary fund to support its expanded scope. in relation to the criteria of financial assessment, for the general scheme, the limit has increased from 175,800 to 260,000. The one that for the supplementary scheme, it has been drastically revised upwards from 488,400 to 1.3 million. The new criteria will take effect took effect since May 2011. So the number of cases would increase by more than 30%. The Council on Legal Aid would conduct timely review. We will regularly come back to report progress. Second, on the question of setting up an independent Council on Legal Aid, the Council has commissioned a consultant to look into the feasibility and the desirability of having such an independent council.
And recommendations will be made to the CE. After the consultancy has been completed, the government will study the findings and will also take views from the Legislative Council, the legal circle, as well as other stakeholders in our community. At present, through its professionals, the Legal Aid Department provides legal aid services to the public in accordance with the relevant ordinance. And there are safeguards in the system to make sure that the Department of Legal Aid can independently and transparently exercise its functions and discharge its duties. And the government will not influence the operation of the Department of Legal Aid. And if applicant is aggrieved by decisions made by the Department of Legal Aid, they can always make an appeal with the High Court. And the High Court has the final decision-making power. And if the case in question has to do with the administration, the Department of Legal Aid will get independent legal advice to make sure that its work is being done very independently. Our legal aid policy objective is to make sure that those who have sufficient ground to instigate litigation or defense will not be prevented from doing so and from seeking justice because of lack of means. And we will examine the efficacy of the extended schemes, and we will make sure that the Department of Legal Aid will continue to provide independent, transparent, and professional legal aid services. And also, we would like to encourage the culture of providing volunteering legal aid services by legal practitioners in Hong Kong. Now it's time for members to put their views to the floor. And these members have indicated interest to speak. Mr. Wong Kok Heng, Mr. Kwok K, Mr. Wong Yok Bun, and Mr. Kok Wing Hung, Mr. Deng Ka Piu, and Madam Emily Lau, followed by Madam Chang Lai Wan, Mr. Liu Cheng Gong, and then Mr. Leung Kok Hong. Anyone else? I'm going to allocate 3 minutes to each of these lawmakers. And so the 3 minutes will be for both questions and answers. The first member to speak is Mr. Wong Kok Heng. First of all, I got a question for the Secretary for Justice. So the Department of Justice is going to be moved to the West Wing of CGO, and this is in line with community opinion. I'd just like to know whether any public space is being set aside so that it's accessible by the public, and also whether any space is being devoted to an exhibition on the history of development of the Department of Justice in Hong Kong, and also how to facilitate contact between members of the public and the legal circle and the Justice Department. And concerning page 2, paragraph C of your paper, concerning the extended legal aid scheme, and you say that there is an appeal mechanism, and the Federation of Trade Union is very concerned about the sharing of costs by the applicant for appeal, and this may be prohibitive to applicant. And now you claim that you are trying to take care of possible financial hardship of applicant. And so, in a case where employees are prevented from instigating legal proceedings because of prohibitive legal costs, so how are you going to help them so that they will not be prevented from seeking justice in getting back wages owed to them because of lack of means? So I'd like to know whether your proposed improvement can indeed address this problem. Thank you. Mr. Zhang? Concerning the expanded supplementary legal aid scheme, of course, its coverage becomes more expensive. It doesn't, however, mean that under the general supplementary legal aid scheme, those applicants that would like to raise an appeal against a decision by the Labour Tribunal cannot use legal aid services. And applicants can still make applications under the general supplementary aid scheme. I'm talking about applicants that are relatively more well off, because the supplementary scheme has raised its limit from $260,000 to $1.3 million. As for the sharing of legal costs, if the applicant is vindicated after the deduction of legal case and after the final deduction of final sharing of costs, we will award the remainder to the applicant that has been vindicated by the court. Can we also hear from the Secretary for Home Affairs? I think you have to wait a little bit. Secretary of Justice can chime in here. Indeed, we have not proceeded to the design stage for the scheme, but Mr. Wong has already pointed out a direction which we may want to go into if it's proven to be feasible. Especially since we would also like the public to enjoy exhibition on development of legal service in Hong Kong, and also to promote the idea of rule of law for the benefit of students. Mr. KWOK, as the Secretary for Justice has pointed out, rule of law is a vital element in Hong Kong's success. And not too long ago, an ex-judge of Court of Final Appeal, Mr. Bukhari, has voiced concerns over possible impact on the rule of law in Hong Kong, and this is very worrying to the public. And he claims that Hong Kong's rule of law is going to face unprecedented challenge. I'm sure, Secretary of Justice, you know what he's talking about. And this is, of course, something that is not touched on in your paper. But to many members of the public in Hong Kong, concerning the request for interpretation of law by the Senate Committee of MPC, actually is something that Judge Bukhari was referring to. And when Mr. Zhang, the new director of Hong Kong China Liaison Office, has raised against the issue of possible legislation to give effect to Article 23 of the Basic Law, Hong Kong people feel even more worried. Once again, this is not touched on in your paper. So, Secretary of Justice, I would like to put this question to you concerning the protection of rule of law and to make the public feel at ease concerning the maintenance of rule of law. Can you tell the public of Hong Kong as to what your plan is going to be? Say, Secretary for Justice has pointed out that in the event where the Court of Final Appeal has made a decision that is not to your liking, you may raise a request for interpretation of law. So, do you still think that an action like that is going to be in the interest of protection of rule of law? And also, legislation for Article 23 is something that really worries Hong Kong people. And so what is going to be undertaking on that particular issue for us? Secretary of Justice, actually, on various previous occasions, I've already mentioned time and again that I absolutely respect the spirit of rule of law, and repeatedly I have explained to lawmakers and to the press that concerning requests for interpretation of law over the issue of domestic helpers in Hong Kong is not considered by us as a possible impact on rule of law in Hong Kong. As for Judge Bukhari's comment, Judge Bukhari or Judge Mr. Ma Dolab has already indicated that interpretation of law by the National People's Congress is not considered by him to be something that is out of order. As for legislation for Article 23, indeed, that is eventually a constitutional responsibility of the administration, but the present term of administration will focus more instead on livelihood issues, and that's why in this current policy address, more focus is being put on livelihood issues. And thirdly, I would like to reiterate that I've never said that I always want a scenario where the government can win even when it loses. And this is something that is put on us by the press. And I've never said that we are going to try to win a dirty battle. Now we've got over a dozen people in the queue, and so you have to wait if you want to put supplementary question. Chairman, now concerning a chief executive that is totally devoid of integrity, I won't call him a chief executive. I won't only call him 689. And in his policy address, there is no mention of the justice system and the rule of law and so on and so forth. And now the Secretary of Justice is here. I have to make some comments in spite of my disdain. The initial impression that you leave us is that you leave us very little room for having any faith in you in your attempt to protect rule of law. And when you were studying law, you were not really interested in social affairs, unlike your peers, like Mr. Zhang Dapming and other peers of yours. And so you weren't particularly concerned about social affairs. Now you have become Secretary of Justice. As for your peers who are more concerned about social affairs, they have become marginalized. And I've tried to filibuster for several months, and I've looked at your legal drafting and so on and so forth. I think the Chinese quality of your law draftsman really is quite rubbish. The basic law says that Hong Kong is a bilingual society, and yet your Chinese language quality in your legal drafting is really very, very bad. And your phrasing is very wordy and very clumsy. And also you claim here very proudly that your law drafting is going to be very easily comprehensible and so on and so forth. I think actually what you have achieved is exactly the opposite. And also common law precedents comprise of English precedents only. And in your report, there is no mention of any specific measures to solve this problem, to smooth over the Chinese language quality of your legal drafting, to make it more comprehensible to the public and to us. As for mediation and concerning creation of posts, I think there are areas where they are really ludicrous. Concerning creation of 3 posts in order to support work of mediation, paragraph 18, you say that you are going to promote mediation within administration, and Secretary of Justice, of course, has to help the administration to deal with dispute resolution. And why do you have to create 2 supernumerary posts in order to do your job? I think that is ludicrous. And also, the creation of such posts is going to create unfair competition to existing mediators. Now, these are my comments. Unfortunately, I did not leave time for you to make an answer to me. And so I'm afraid I just have to say that I'm very unhappy about your report. Actually, what you said in the latter part of your comment has to do with item 3 on the agenda, and so we'll have time again to deal with that in due course. Next, Mr. KWOK. I'd like to ask a question about class action. Your report says that the working group is going to have its first meeting this year. And this is something we've been concerned about for many, many years. We hope that you can achieve progress on this as soon as possible. I'd like to know, when can the working group come back to us for a report? And when can you come up with a definite plan for our benefit to let us know exactly when can class action be implemented? Thank you. As the paper has pointed out, after the working group has had its first meeting, we will then be in a position to know the views of various stakeholders.
Well, at this stage, well, this is a very preliminary stage. We cannot be very specific to say that we have a timetable like this or that. I understand this is a matter of concern, and members here are paying attention. But that's understood. I fully understand your concern. But members should also understand that there are divergent views. All I can say is that we'll do whatever we can to take forward the matter. Well, it would be best if we can come back to this panel in the middle of the year just to report progress. And I want to know whether anyone from the Legal Aid Department is represented in the working group. Secretary? Yes, there's a representative from the Legal Aid Department serving as a member on the working group. Mr. KWOK is asking for a progress report in the middle of this year. Whether it should be the middle of this year can be further explored, but in principle, we will be coming back regularly to report progress. Okay, so we'd like to get another chance to discuss it later on. What about making the Legal Aid Council independent? The two legal professional bodies have issued statements asking for independent counsel. What's the position of the government on this? And also, when are you going to give us the report of the council? The Deloitte report. Well, Secretary for Home Affairs, I mentioned 3 points. And the second point is about the commissioning of a consultancy study. When are you going to give us your report? The Secretary would like to supplement. Well, this is my understanding, because I'm also concerned about the subject. I know that the Legal Aid Services Council, the chairman of the council, is not sure when the report will be out at this point. Mr. Tang Ka-biu, thank you, Chairperson. In paragraph 31A, it said that you are going to prepare a bill, the Contracts Rights of Third Parties Bill. Will the employment ordinance be covered in this bill? And also for the legal aid and supplementary legal aid schemes, the views of the trade union and the labor sector are very clear. Well, usually, even if the employee wins a case, the employer will still lodge an appeal, but the employees does not have the means to contest an appeal. And if that case goes against the employee on appeal, that will become a precedent case. So I hope employees who won in the first instance would automatically get legal aid in case of an appeal. As for the next item, mediation, there's no accreditation system at present, but I've learned from the mediators, some mediators, and also the 30 training bodies complaining about making one particular body the exclusive accreditation body, because mediation is about resolving civil disputes in an informal and inexpensive manner. If you set the thresholds at a very high level, then you are excluding a lot of mediators who are now providing the service. Secretary for Home Affairs. Well, I think this problem has been resolved when the bill was considered here. And that is if there is an appeal arising from a labor dispute, the legal aid scheme can provide assistance. Secretary would like to have this overarching umbrella organizations for this. Well, it's the result of the consultation. It was widely supported that we should have one single accreditation body. I understand the concern whether the qualification criteria will be set too high, thereby excluding many existing or incumbent mediators. We'll certainly pay attention to this in the process. That single body will be working out the accreditation system, and in doing this, they will be trying to be accommodative. Ms. Emily Lau. Madam Chair, I would like to ask a question about legal aid. On the 14th of January, at the ceremony of the opening of the legal year, a number of speakers have opined that in an affluent society like Hong Kong, we still have many people who cannot get legal aid. And as a result, they become litigants in person. And it's a waste of money because those who suffer will be the judges. And the whole process will become longer. It's unfair all round to all the parties. I think the Secretary understands our concern. That's why in his opening remarks he has told us that another 100 million has been devoted to legal aid. Please tell us, Secretary, how many litigants in persons are now handling their own cases in the court. As for the independence of the Legal Aid Services Council, the previous council was in favor of this, and now you backtrack and then ask a consultant to look into this. It's a delaying tactic. And Mr. C.Y. Leung has set a very bad example for you. We want the Legal Aid Department to be independent. We want to make bigger provisions for legal aid to benefit more applicants. Can we have something more proactive and positive from the Secretary? Secretary? Well, the SAR government has always been positive about this. The objective is to ensure that in Hong Kong, no one will be denied justice because of lack of means. But the responsibility doesn't rest with the administration alone, I believe. This objective is shared by the legal professions. When we try to expand the scope of legal aid, we knew we had to tackle one important issue, and that is the financial commitment. And in particular, if the legal aid department is to be made independent of the government, then what's the financial commitment? How is the legal aid department going to get the funds it needs? HAB does not really insist that it should be under the HAB. But we have to look at the long-term financial resources how is it going to be funded, and how is it going to be transparent in funding. One of the reasons why we have more litigants in person is because litigants cannot afford legal costs or legal representation. We are also providing assistance to these litigants in person through another scheme. The member refers to the remarks made at the ceremony of the opening of a legal year. Well, that was a very solemn occasion. It's regrettable that the representatives or the chairman from the Bar Association said the HAB shifted the responsibility of facilitating class action to the Consumer Council. That's an unfounded accusation. Well, please don't use my time to... Secretary, I want to make 2 points. One, a clarification. The consultancy study, is something that is done under the Legal Aid Services Council Ordinance. And under the ordinance, the Council is the duty-bound to look into the feasibility of setting up an independent legal aid body. And therefore, the Council commissioned the study. So it's by no means a delaying tactic employed by the government. The current term of government is very concerned about this. As I said on the same ceremony, we understand that this is an issue, and we would certainly look into the issues after we have received the Council's report. Procedurally, the reports should come from the Council. We should not try to speculate on what they are going to be about or what they are trying to recommend. Ms. Ann Zhang, my question is for the Secretary. In recent years, in relation to mediation services, well, it's good news to the grassroots or people with limited means because they can avoid costly legal action. But it's not well known, it's not well understood. Many people still do not understand what mediation is about. And they don't know what can be served through mediation. So what can you do, Mr. Yun, in conducting more publicity activities to promote this? Secretary, we have a new steering committee on mediation. And there are also 3 committees, or 3 bodies. The third one specifically on promotion. Some ongoing, which we are also going to continue, will be the organization of seminars. And would like to facilitate and promote district mediation services. This is one of the main areas of our work. So there will be more publicity to be carried out in the districts. In other words, we are not just concentrating on the commercial disputes, but rather disputes of a district nature. And the steering committee is also looking into the possible extension of mediation to, say, building-related disputes such as water seepage. That will also be one of the main areas that it would look into. And I certainly agree that we should step up promotion. Mr. Martin Liu, I want to ask a question about the pilot scheme on legal services in Qianhai, in particular the one on partnership. What is the progress so far? Do you have a concrete timetable concerning the scheme, the pilot scheme? Second, under the pilot scheme, are you going to cover both branches of the legal professions? Would it cover barristers as well? And we all know that China has a policy that for the mainland will open up its service industry to Hong Kong in the last year of the 12 five-year plan period. And professional services should be covered. Would the Qianhai scheme be the very first step? The last year of the 12 five-year plan is 2015, and we haven't got the pilot scheme. So how can you ensure that there will be a comprehensive opening up at the end of the 12 five-year period?
Take question number 2 first. Concerning the Qinghai pilot scheme, conceptually, there will be no differentiation between lawyers and barristers, solicitors and barristers. Actually, I myself have communicated with relevant representatives of the two professions. Probably for barristers, they've got internal guidelines that they need to reformulate in order to take full advantage of the benefits from the pilot scheme. And this is entirely up to the Bar Association as to what they are going to do. And the Secretary of Justice, of course, will not influence their decision-making. As for the timetable for the joint venture or the 12 five-year plan and the full opening up of the mainland service industry, I can tell you that there is no fixed timetable as yet. But what I can tell you is that I have met with the mainland representative for the Qinghai scheme. And in December, when I was visiting Beijing, I also had the opportunity to talk to mainland authority about the Qinghai scheme and its implementation. And in coming days, we are going to brief relevant counterparts on the mainland as to why our proposed scheme is going to achieve a win-win scenario for both mainland and Hong Kong. Mr. Leung Kwok-hong, of course, the legal aid department is very important because if someone has to instigate legal proceedings and if he has lack of means, then no justice can be achieved. I myself have represented myself many times in court, and the latest case, of course, when Mrs. Yu Leung tried to come after me, asking me to pay legal costs for a case that I instigated against him. Now, concerning the Bill of Rights Ordinance and also the International Covenant on Human Rights, will you make these two important pieces of document a boundary within which free legal aid should be provided? Now, if a case is being brought under these two international documents and if a case is being adjudicated on, then it will become a precedent. Concerning my own case against C.Y. Leung, which has to do with whether election petitioning should be confined to 2 weeks and shouldn't it be expanded to 4 weeks. But the Court of Final Appeal judges said that this was something that should be examined, and they also said that this should be further looked into. I only have one request. Now, concerning these two documents, the Bill of Rights Ordinance and the International Covenants on Human Rights, now these two actually copy one another. Now, would you consider that these two documents will form the boundaries within which free legal aid will be provided? without giving consideration as to whether there is any chance of success and so on and so forth. I myself have instigated one legal case which had to do with whether I would still be eligible to run for a legislative seat if I had to serve jail sentence. And the legal aid department said that if I could come up with $660,000, then the legal aid department would be willing to underwrite my case. $660,000, of course, was a lot for me, and so I decided against using legal aid service, and I represented myself. So I couldn't be awarded any legal costs, even if I won. So I hope that the Secretary for Home Affairs and Secretary of Justice can, in earnest, consider this. Because for human rights cases, sometimes they may be considered frivolous, or they may be considered trifle case, but they are very, very important to our community. Okay, let's leave some time for the administration to respond. I thank Mr. Leung for his observations and his remarks. My understanding is that other territories are also playing by similar legal aid principles, and they always give weight as to the chance of success of a particular application. I can tell you that no territory has a legal aid system that will give no weight to the chance of success of a case before awarding legal aid services. And so in principle, your recommendation definitely is very creative and original, but at this point in time, I do not see any good justification as to why your suggestion should be adopted. Of course, in due course, when we are in a position to do any review, your suggestion can definitely be considered. But at this point in time, I really don't see anywhere else in the world where a similar system as proposed by you is actually being put into place. Now, concerning Bill of Rights Ordinance and also concerning international covenants, now, if there is no asset limit, then actually I understand the Secretary. Now, if there is no merit, then of course the case will not go ahead. But asset limit can be a very big stumbling block. Mr. Leung, actually we heard you loud and clear. Let's move on. So I was asked to come up with $660,000. Now we have to give time to other members who have been in the queue for very long. Mr. Teen, I've got two questions. One has to do with mediation, the other has to do with Qianhai. For Qianhai, I don't understand what exactly is it about. It seems that it is really not very substantial. So now I'm given to understand that this year you are going to promote the use of Hong Kong legal services by enterprises in Qinghai and Nanshan. And in the contracts, you are promoting that Hong Kong laws should be used instead of mainland laws. So, of course, Hong Kong legal practitioners will have to get involved. And also, will there be a need for two set of judges and two set of courts? And also, say, if a company is considered by court to have lost its case, and yet the company has its asset on the mainland, and so will such asset be not touched by the winning party if the asset is placed outside of the Qianhai area, and so on and so forth? I'm not a legal expert, and so I want to know more about this Qianhai scheme. The second question has to do with mediation. The last Secretary of Justice said that in the 2010 policy address that the community service review scheme will be re-examined concerning its efficacy. So we've got community centers in Leung Hin Lei and so on and so forth. I'd like to know whether such community centers in Hong Kong and also in NT area will indeed be used by you for the implementation of mediation service. Now, for the Qianhai proposal, actually is a full package of measures. Apart from promoting use of Hong Kong laws, we also promote the selection of Hong Kong's mediation service in the event of dispute. For Qianhai, actually there is a court on commercial dispute, and if Qianhai is to become the location for commercial disputes, then the commercial dispute court can then kick in to operation. And our proposal is to encourage enterprises to not only use Hong Kong laws, but to use Hong Kong's mediation service in the case of commercial disputes. And such services can take place either in Qianhai or in Hong Kong. And this brings us to the question from Mr. Tan about implementation. If our recommendation is being adopted, then the mediation or the arbitration, whether it's being done in Qianhai or in other parts of mainland or in Hong Kong, will then, in accordance with the New York Covenant, be executed on either in Hong Kong or on the mainland where the assets are being allocated. As for the use of community centers for mediation or arbitration service, at present, the scheme is working quite successfully, but of course there is still room for improvement. And this, of course, brings us to the next item on the agenda, and my colleague Mr. Lee can furnish you with more information. Mr. Wu has just come in, and then followed by Mr. Jia Wai-jun, and then we have to draw a line down. Mr. Wu Chi-wai, I've got two questions. First of all, concerning legal aid, we have come across many cases where even the winning party is able to get a very small compensation because of the sharing out of costs. Now, of course, the winning party has the recourse to go after the losing party for the award of legal costs. But I'd like to know whether the winning party also has to share in some of the legal costs. And also, we have come across some very straightforward cases, such as divorce cases. And actually, both parties have agreed to divorce, and still they had to go through legal aid proceedings. I'd like to know, for such straightforward cases where both sides are in agreement, would you be possible to educate the parties involved to not to recourse to legal aid, since they are already in agreement, they actually don't need to resort to legal aid, and so that legal aid expenditure can be saved. For the first question, if the recipient of legal aid has won a case, and in the assisted case, which the party has already won, he is being awarded damages or being awarded compensation, and if such costs cannot be received from the losing party, then we will have to deduct the costs from the damages awarded. And this is the first legal charge that the Commissioner for Legal Aid is eligible for. And this is a principle that is being applied in all Commonwealth territories. As for the second question, if the applicants are a married couple, and in the case of their divorce, they are in agreement in divorcing each other, then the court actually can provide them with a simplified set of procedures so that they can apply for divorce without resorting to legal aid. Now, of course, there could be complications, the sharing of asset and the sharing of custody over children. In those more complicated cases, then they may have to resort to legal aid services. Now, concerning the first legal charge that the Commissioner for Legal Aid is eligible for, would you consider the actual financial conditions of the applicant so that you will revise the amount of legal charge that you are going to impose on them so that they will not be deprived of their financial means? Actually, in the process where litigation is ongoing, the department is going to remind the applicant as well as the legal counsel representing him or her that they need to give consideration to possible damages that could be awarded to them. and also has to give consideration as to whether the counterparty is capable of paying legal cost. And if the applicant, after the case is being judged on, can prove to us that if the Commissioner for Legal Aid is to exercise his right over first legal charge, he will encounter great financial hardship, we do have the discretion to reduce the amount given to the Commissioner for Legal Aid through first legal charge.
Mr. Paul Chair. Well, in the second part, you talk about we want to have a first-class prosecution service and to uphold justice. I don't know how many people would regard prosecution as a kind of service. On many occasions, it's sometimes not very fair to litigants. For example, too many cases are listed to suit the diary of legal officers, and or the cases where some of the cases will have to be rescheduled. And sometimes the accused has to appear just for the sake of taking deed. So it's not user-friendly. Not to mention that it's by no means professional and user-friendly prosecution services. Can you be really user-friendly without compromising justice so that we can save time? Many people, like taxi drivers, are forced to plead guilty because they don't want to lose a day's business. Can you do something to improve this, Secretary? Secretary, thank you, Mr. Chair. In November last year, we convened a large-scale forum to look into possible improvements to our criminal justice system. Two areas are brought up by Mr. Chair in his questions. We have to work with the judiciary in listing matters. It's not within the ambit of the DOJ, but certainly we can talk to the judiciary. Second, is personal appearance mandatory for pre-ticking? Well, that's subject to law. Of course, we can review in our future review of our criminal justice system. We can make some amendments as to the requirement of court appearances, so as to make it user-friendly. Well, for example, I would like to refer to some cases in the small claims tribunal whereby time and again the case has to be postponed, and also even if the case has been duly adjudicated, enforcement is always a problem. Well, I think it's really about the civil law reform, and it's not under the ambit of the DOJ. All right. I also have a few questions. Middle-class people are not eligible for legal aid. Our legal system is set to be for the most rich and the most poor. And sometimes we are talking about big property developers as your opponent. And I was personally involved in litigation, and legal aid was not possible. Although we have increased the asset and income limits, they are still too low. So perhaps you should consider increasing the limits even more, especially under the supplementary scheme. And last time we suggested that the compulsory auctioning of properties should be covered. Because you have aged property owners who know little about their rights in the auction, and mediation in such cases is only voluntary. So we would like to propose arbitration for building-related cases, because arbitration would spare you from the need to go to the court. So those were some of the suggestions we made previously. I would like the Secretary to consider them again, and also can some improvement be made to the Building Management Ordinance Cap 344. Well, we love and hate owners' corporations because they can both do a lot of good and a lot of bad things. And there are many people who like to see that the ordinance be improved. Well, you mentioned compulsory auction and owners' corporation, and whether we should provide for arbitration. We have to consider this carefully. Arbitration, like mediation, can only be carried out with the consent of the parties. We cannot force anyone to go for arbitration. And in promoting mediation, we'll certainly look at possible scheme. There's a pilot scheme on auctioning of properties, or building real properties. As for Cap 344 and whether there can be a review, I can say a few things, but perhaps the Secretary for Housing or for Home Affairs may be in a better position to respond. If there are voices calling for legislative amendments, I can say something. I can do something as chairman of the LLC. I can refer such a request to the LLC, but the Policy Bureau may have other factors to consider. Madam Chair, we have started to review Cap 344. There's a dedicated committee working on this. Further expansion of the supplementary legal aid scheme. Well, certainly we would look into this, and also mediation for building disputes. We have a mechanism to promote mediation to the parties on a voluntary basis. We would like to have compulsory mediation in case of compulsory auction of real properties. Yes? You have to ask the Secretariat. I'd like to thank the S4J and SHA for attending the first item. We move on to the second item. Yes, you want to say something, Secretary? I want to make an amendment. I mentioned New York Convention. I should have mentioned the agreement on reciprocal enforcement, but that's based on the New York Convention, so I just want to clarify the point. All right, we move on to the next item. And it's about mediation, on which many members have commented, and also the mediation body to be set up, CB 4321/12-13/05 and CB 4321/12-13/06. We have no one from the Hong Kong Bar Association for today's meeting. They have provided a written submission. The next paper is a CB 4321/12-13/07, background brief prepared by the Secretariat. With regard to the recommendations published in February 2011, the DOJ would brief members on issues such as public education, accreditation of mediators, and publicity and public education. Earlier on, the subcommittee on the commencement notice would like us to look at the future operation of Hong Kong Mediation Accreditation Association Limited and also its work in the future. I would like to welcome Mr. Lai Ying-si from the DOJ. Thank you. This paper is on the progress regarding promotion of mediation. The DOJ has done a lot of work on this over the past 4 years, and we have been reporting to this panel regularly on the progress. Before I refer to the work of the task force, let me briefly mention the development in the past 4 years. This started in 2007 in the policy address, and in February 2008, the SPJ set up the task force to take forward the matters on various fronts. In February 2010, the task force published a report listing out 48 recommendations, and then there was a 3-month consultation exercise. The recommendations were supported by the public who gave their views. And in 2011, a task force was set up to look into the recommendations and ways and means to implement. And 2 years later, most of the 48 recommendations have been implemented. You may wish to refer to Annex A for all the 48 recommendations. I do not intend to go over them one by one, but if members have questions, my colleagues and I will be happy to supplement. And I would like to mention a few things. Mediation Ordinance. On the 15th of June 2012, the Mediation Bill was passed in this Council. The bill was passed after 32 organizations or individuals were consulted. And the objects of the mediation ordinance are to promote, encourage, and facilitate the resolution of disputes by mediation, and to protect the confidential nature of mediation communications. That's in Section 3. And the ordinance applies to the government. And maybe I can also clarify here that we are to promote and facilitate mediation. This is not like arbitration. That's the common practice in many common law jurisdictions. So after the passage of the mediation bill, the task force has also completed its examination of qualifications. there was consultation. At first, the recommendation was to set up the accreditation body in 5 years' time because it was rather complicated. But for those who were consulted would like to have it set up as soon as possible because accreditation of mediators is an important task. So the task force was asked to look into the quickest means to implement this. After talking to the sector, we decided that we should set up a limited company by guarantee, a company limited by guarantee, and that is we should set up the Hong Kong Mediation Accreditation Associated Limited based on this, and it's a non-statutory body. They're all practitioners. This company was incorporated on the 28th of August last year, and they are embarking on various tasks at the moment. And they will be fully functional by April this year. And through the steering committee, the DOJ would take close communication with the with the HKMAAL, in particular in relation to accreditation criteria.
The third important task completed by the task force is public education and publicity. And this will include the production of publicity, video, as well as audio recordings. And its theme is called Mediate First. And a Media First conference was also held on May 11th and 12th, 2012. And over 200 members of the industry have been attracted to come to the occasion, and so it was very successful, and so such hosting of conference will continue. As for the other activities undertaken by the task force, they are already in our schedule. As for the way forward, we've communicated with industry, and the industry is of the view that the government should not stop after implementing the 48 recommendations and leave the industry to its own means. Actually, the government should continue to help the industry, and that is why the Mediation Steering Committee is being set up towards the end of last year. And the first meeting of the Steering Committee was already called on January 8th. And representatives from the social worker circle, and from medical circle, and from architectural circle, and all other relevant stakeholders sit on the steering committee. And there are 3 working committees under the steering group responsible for the 3 major areas. First of all, concerning the monitoring over the rolling out of the legal framework for the implementation of the ordinance. And secondly, concerning training for mediators and accreditation of mediators, and so on and so forth. And the third working party is responsible for continuing to promote and expand the adoption of mediation as a means for dispute resolution. And so there will be 3 standing working parties under the steering committee. And the steering committee, of course, will have its work cut out for it. And that's why we need to create additional posts in order to support new activities to be undertaken by the task force and the steering committee. So this is what we have done to promote mediation during the past 4 years. And this is a facilitated kind of mediation instead of a judicial kind of mediation. And this is something that is adopted by many other countries. And we promote mediation not only for the resolution of commercial disputes, we also want mediation to be adopted by the grassroots part of our community for grassroots cases, such as for disputes over buildings and disputes over family issues. So we want mediation to be promoted also to grassroots and livelihood cases. And the policy address has made it very clear that the Secretary of Justice and the Department of Justice is going to commit itself to the promotion of mediation activities in Hong Kong as well as on the mainland. And mediation, therefore, is going to be a very important focus of work for ours. And the Department of Justice actually has done a lot with mediation. And in February 2009, the Justice or Judiciary has come up with Directive 31. It has to do with the use of writ at district court level and a high court level, and mediation must be resorted to first. Otherwise, full award of legal costs will not be granted. And the judiciary actually has done a lot in this regard in order to promote mediation. So that's my presentation. And if you have any questions, I'll be happy to answer them. Ms. Maureen, representing the Lawyer Society, will give a representation.
The Law Society welcomes the creation of the supernumerary post to promote and facilitate the use of mediation in Hong Kong. Since 1996, many Law Society members, on a pro bono basis, have done much to promote and facilitate the use of mediation in Hong Kong. So we thank you for the opportunity to add our experience to the administration's proposals. Balancing the needs of the community, having effective use of court facilities, and ensuring Hong Kong core values requires a multi-door approach to justice. Mediation can result in what litigation often does not allow: dialogue, reconciliation, and closure. Arbitration allows resolution in a private setting. Litigation may be the surest path to uncover truth, right wrongs, and achieve justice. The choice of which avenue to take depends on the parties and the issues involved. Clearly, it is horses for courses. Whoever holds the post to be created in the DOJ must appreciate and be supported by the administration in recognizing and upholding the core principles of mediation: simplicity, confidentiality, voluntariness, self-determination, and open dialogue. If this post is approved, we think it helpful for the Law Society to be allowed to comment on the proposed criteria for the candidates and job specifications. There are 3 reasons for this. In the keen adoption of mediation, we are noticing the inadvertent slippage of these core principles. We see the adoption of paradigms from litigation and notions of accountability to others outside the room. We find the increasing use of rules, paragraphs, subparagraphs, and requirements to show settlement agreements to administrators. In our view, the post holder needs to be able to recognize when the mediation process is being turned into an arbitration process or a litigation process, and to have the authority to stop that shift. Mediation has proved to be a viable avenue and force when used appropriately. And any force, like any Star Wars fan can tell you, has a dark side. There are reasons why mediation schemes limit legal representation, but there is always the proverbial little old lady who can be disenfranchised by that requirement. Confidentiality agreements encourage original and private solutions, but they also encourage the concealment of patterns of corporate misconduct. The post holder needs to be able to appreciate balance of power issues, how powerless people may be empowered. The post holder also needs to be able to comment that despite the existence of an issue-specific mediation scheme, that maybe it is not in the interests of justice for a particular client to be required to participate. In many jurisdictions, the perception is that mediation was adopted primarily because it could clear court lists. Hong Kong is fortunate in that it can learn the lessons from other jurisdictions, so that, in our wisdom, we do not get subverted by monetary concerns above all others. The post holder needs to appreciate that despite the benefits of mediation, the paramount principle is that everyone is always entitled to access the court and to have legal representation in doing so. Thank you.
多謝 Mr. Muller。咁呢就
Thank you, Mr. Maureen. Now it's time for members to put questions to the floor. I'm going to read out the list. Madam Mei-fun, Madam Emily Lau, Mr. Kwok Hung, Mr. Tan Kah-pio, and who else? Mr. Yu Si-wing. Each will be given 3 minutes, including question and answer. Mr. Mei-fun. The paper mentions that the HKMAAL actually has caused some concern among existing mediators. Existing mediators are worried that the Hong Kong MAAL may put pressure on existing mediators, because all along you have been saying that you would like to adopt an inclusive approach, i.e. existing mediators will always be included in the future mechanism. But what existing mediators are worried about is that they may be excluded from the future mediation mechanism. And so I'd like to know exactly how the Hong Kong MAAL is going to operate. And also concerning the training programs, will the training programs be vetted by the Hong Kong MAAL in terms of teacher qualification, in terms of curriculum, content, and so on and so forth? If the Hong Kong MAAL is to adopt a very restrictive approach over vetting in terms of qualification and curriculum, how can you be successful in expanding the coverage of mediation service in Hong Kong? Concerning accrediting qualification of future mediators, indeed, that is one of the major tasks of the Hong Kong MAAL. And I would like to stress that this is a company limited, and this is not a statutory organization. I understand that the present ordinance will not stipulate that someone will not be able to work as a mediator unless he is a member of a certain organization. As for how the membership of the Hong Kong MAAL is to be played out, and so on and so forth, we will have to wait and see. But the steering group on mediation is going to maintain a very close contact with the Hong Kong MAAL and to make sure that whatever they design, whatever they adopt is reasonable. I understand that Hong Kong MAAL so far has adopted an inclusive approach, i.e. to try to include as many existing mediators as possible. But of course, they also will have to draw certain lines over qualification, and they will have to adopt certain standards and certain boundaries. At this point in time, the Hong Kong MAAL is still in its infancy stage of its work, and it will really kick into full operation only from April. And the steering committee on mediation is going to maintain a very close communication with Hong Kong MAAL before the next step is being decided on. What about the training programs and the vetting of training programs? Please give us a very simple answer. The Hong Kong MAAL is not going to provide training programs, but what is more possible is that they're going to make recommendations as to what kind of training someone has to go through before he will be considered a qualified mediator. Madam Emily Lau.
I want to ask a question about resolution of building disputes. Can these disputes be handled through mediation? Because disputes like these can be very annoying to the building owners. Well, there are many types of mediation. Building management is an important part. The future steering committee, as the secretary has said, will be paying attention to such disputes like water seepage. There have been formal and informal mediation cases. Well, I haven't got the statistics, but sometimes it can be resolved through an informal mediation. A lot would depend on the quality of service provided by the mediator. The steering committee will look at possible room for improvement. As regards the second point made by Mr. Lau, building management cases. Well, the task force has now secured two venues, Leung Hin Lei Community Hall and also Lighton Hill Community Hall, for the purpose of providing mediation venues. But the utilization is not very high. There is just 50-odd cases per venue at the present moment. If there are more cases to handle, of course, the two venues will not be sufficient. So this will be a subject that the steering committee will be looking into. Well, I think the steering committee should look into this carefully, because building disputes are an important area in which mediation can be promoted, and if there are insufficient venues, you should work out a solution. Mr. Dennis KWOK, I want to ask a question about Hong Kong MAAL. In a previous meeting, we expressed our concerns whether the Hong Kong MAAL will be efficient enough or fair-minded and transparent. Mr. Lai, well, the Hong Kong MAAL was incorporated in August last year. It's a company limited by guarantee, just like the Financial Development Council, right? Well, it was the recommendation of the task force to set up a statutory body, but that would take a longer time. Do we have any officials in the Hong Kong MAAL? No. And you're not going to provide resources or manpower to Hong Kong MAAL. Well, the Hong Kong MAAL will look into resource requirements. We cannot rule out that they will ask for resources to be provided by the government. What if the resources? Well, I think the resources will mainly come from the Law Society and the Bar Association, if I'm not mistaken. Well, there are four important founder members: Hong Kong Bar Association, Law Society, Hong Kong IAC, and Hong Kong MC. The four founder members, and they would provide the resources, and for the time being, nothing will come from the government, and there will be no government officials sitting on the board of this company, and there will be no ex-officio membership. So it's not like the proposed Financial Development Council. although they are both companies limited by guarantee. But in terms of government participation, it's very different. Am I correct? Well, I haven't looked into the composition of the proposed Financial Development Council. This Hong Kong MAL is a company limited by guarantee. We don't have any official sitting on the board, but we cannot rule out that there are people who has a close relationship to the government serving in another capacity. But because otherwise communication would be difficult. We want to maintain close communication with the Hong Kong MAL. So I cannot rule out concurrent membership in order to maintain close communication. Mr. Tang Ka-biu, I want to voice some concern here. According to some other members, these founder members are professional bodies. They set up this industry organization. And those who are community organizations or those who are not mediators dealing with major cases will be concerned that in the process you are trying to eliminate these small-time mediators and small-time mediation training providers. But mediation is not just about commercial mediation. So academic qualification is not the number one requirement, because you also want to cover family disputes and community disputes. I know that there are over 30 training service providers, and many mediators have been trained by these training providers. And how many mediators rely on mediation as the main source of income, and how many of them are just doing this as a sideline business? And there are many cases which are recognized under the government qualification framework, and there are also courses recognized by the Continuous Education Fund. If they come up with something very different in terms of accreditation, what would happen to these courses and mediators? Well, they will look into various matters, such as the accreditation and also the admission criteria. Of course, this is not something for the government to decide, but through the steering committee, we will maintain liaison with the Hong Kong MAL. And there would be a need for consultation or conducting surveys. So they may take this up. They may take this up in their future work. Well, that's very simple as a response. But you must assess the impact on existing mediators, and there are already training courses which are accredited, which are recognized. What are you going to do with those? Our members of the Hong Kong MAL are aware of these matters. I believe they would take into account those points mentioned by the member. Well, your response would have been appropriate if if the government would not be involved in a very follow-up manner, and if it's not going to be turned into a statutory body, then it would be okay. Mr. Yu Si-wing, well, mediators can handle cases after properly trained. Would they be doing their cases under supervision in some cases? If a case is mishandled, what would the government do? do you or does the administration have any plan to enhance quality of mediation or quality of service offered by mediators? Mr. Lee. We are concerned, and the public are concerned about the qualification and training required for mediation. And this is, of course, a major task for the Hong Kong MAL. The Hong Kong MAL will come up with criteria. And also, they would set up a mechanism to handle complaints. After they have set up all these procedures, then the concern of lack of monitoring will be addressed. I think we are talking about allowing users to make their views known or to make representations, and if a good system is set up by the Hong Kong MAL, then we'll be able to have a good mediation system. And of course, the Hong Kong MAL will be interested in enhancing quality of service. And how the quality of service can be enhanced through continuous training. I think all of these would be implemented step by step. Mr. Yu, if it's up to the user to decide whether there's any supervision in the service, it's rather subjective, because if there's a claim or if there's an allegation made in relation to a case, there's no third party that can help to resolve the matter. Mr. Lee. Well, I think the question is whether there's a channel for people to lodge a complaint or to make representations. And if there's a channel, what would happen next? Well, I think it's the duty of the Hong Kong MAL, because they must put in something to instill confidence of the user and to promote mediation as a result. Yes, I also want to raise some follow-up questions. Actually, I mentioned some of these in the Bills Committee on the mediation bill. Very early, in the very early stage, people were trying very hard to promote mediation in the community, and those people might not be lawyers. So the future system, in my view, must be fair. The Hong Kong MAL will be the authoritative organization in the future. We have to make sure that the system is perceived to be fair. We don't want to have something like the system to regulate the practice of traditional Chinese medicine, because there were a lot of complaints that some of the practitioners were somehow excluded from the system. We understand that to make mediations successful, we need to have other professionals who would chip in. For example, social workers, psychologists, and doctors will have to be involved. And of course, legal practitioners are also essential. So how can we be inclusive as possible? Actually, when we were on agenda item number 1, some members already asked some questions about mediation. I hope something can be done about training. I have to declare my interest as a professor in law, but of course I don't teach mediation subjects. A lot of people have been providing the training. They have a wealth of experience. Will the Hong Kong MAL take advantage of these training providers? Because I hope, Mr. Lee, you can say something, tell us something. The ordinance has been implemented for a few months. What have they done in this regard? Mr. Lai? Well, the Hong Kong MAL was only set up in August last year. I understand they have been working very hard. They have been trying to establish a secretariat, for example, and also to secure resources.
工作。
And according to our contacts with the Hong Kong MAL, we are given to understand that they're going to start their operation in earnest from April this year onward. And of course, one of their main tasks would be to outline the accreditation criterion for qualification of mediators. And according to what we understand, Hong Kong MAL does not have any plan to operate any training programs themselves. They're going to leave it to the industry. However, they will lay down the rules which say that if a person would like to join Hong Kong MAL, they will have to fulfill certain training requirements in terms of the hours of training that the person has gone through, and also the standard of training that the person has already achieved before the person is granted membership to Hong Kong MAL. Because they have started work only a short time ago, we're going to maintain a very close contact with the Hong Kong MAL to see how their thinking is going to pan out. And also, we are going to give feedback and advice to them as and when necessary. Actually, the Bills Committee on Mediation Bill has already considered the possibility of asking delegations or deputations to come along to give views. Now, if you agree, then I'm going to contact with organizations that have given views before on this, and to see whether it is appropriate for deputations to be invited along to come to a meeting of this panel to give views, because that's indeed being suggested as one of the follow-up work to be done by the AJLS panel on promotion of mediation. Okay, I think we can wrap up our discussion on this item, and so we hope that Mr. Lai is going to relay our views in earnest to Hong Kong MAL. Right, item 3 on the agenda, and this has already been touched on by several colleagues concerning proposed creation of post. Proposed creation of one supernumerary post of Deputy Principal Government Counsel in the Civil Division of the Department of Justice. And I refer you to paper CB bracket 4 321 12-13 bracket 08. The government has already tendered a paper on the creation of this proposed post. So this is about the creation of this Deputy Principal Government Counsel post for 2 years. And it's DL2 on the Directorate pay scale. And this is to follow up on promotion of mediation and the development of mediation. And after the AJLS panel has discussed it today, then in January and March, the government is going to approach the Establishment Subcommittee and the Finance Committee for the submission of relevant proposals to create a post. Now we're going to ask the official to brief us on this proposal. So earlier on, we were talking about the promotion and development of mediation in Hong Kong, and so a lot of work awaits to be done, especially with regard to determining a qualification level for mediators and how to take care of the interests of present mediators and the industry and so on and so forth, and how to promote mediation among grassroots community. And also, after the rollout of the mediation ordinance, we're going to review its efficacy to see whether there is any room for improvement and whether there is any need for legal amendment for improvement. And so we can see that in the coming years, the work involved is going to be rather complicated and rather substantial. And so we need a Deputy Principal Government Council to be on top of this. Even though this is going to be ongoing duties, we are going to propose the creation of only a supernumerary post only for 2 years in order to economize on resources expenditure. And so we need this post to be created so that mediation can be better promoted and developed in Hong Kong, and we hope that Legislative Council can support it. Now we ask Madam Maureen to give us the views of the Law Society.
For the tape. The Law Society welcomes the creation of the post to promote and facilitate the use of mediation in Hong Kong. Since 1996, many Law Society members, on a pro bono basis, have done much to promote and facilitate the use of mediation, and we thank you for the opportunity to add our experience to the administration's proposals. Balancing the needs of the community, having effective use of court facilities, and ensuring Hong Kong core values requires a multi-door approach to justice. Mediation can result in what litigation does not allow. Mediation allows dialogue, reconciliation and closure. But arbitration allows resolution in a private setting, and litigation may be the surest path to uncover truth, right wrongs, and achieve justice. The choice of which avenue to take depends on the parties and the issues involved. Clearly, it is horses for courses. Whoever holds the post to be created in the DOJ must appreciate and be supported by the administration in recognizing and upholding the core principles of mediation: simplicity, confidentiality, voluntariness, self-determination, and open dialogue. If this post is approved, we think it helpful for the Law Society to be allowed to comment on the proposed criteria for the candidates and for job specification. There are 3 reasons for this. In the keen adoption of mediation, we are noticing the inadvertent slippage of these core principles. We're seeing paradigms of litigation and notions of accountability to others outside the room. We find the increasing use of rules, paragraphs, subparagraphs, and requirements to show settlement agreements to administrators. In our view, the post holder needs to be able to recognize when the mediation process is being turned into an arbitration or a litigation process, and to have the authority to stop that shift. Mediation has proved to be a viable avenue and force when used appropriately, but like any force, it has a dark side. There are reasons why mediation schemes limit legal representation, but there is always the proverbial little old lady who can be disenfranchised by that requirement. Confidentiality agreements encourage original and private solutions, but they also encourage the concealment of patterns of corporate misconduct. The post holder needs to be able to appreciate balance of power issues, how powerless people may be empowered. The post holder also needs to be able to comment that, despite the existence of an issue-specific mediation scheme, that maybe it is not in the best interests of justice for a particular client to be required to participate. In many jurisdictions, the perception is that mediation was adopted primarily because it could clear court lists. Hong Kong is fortunate in that it can learn the lessons from other jurisdictions, so that in our wisdom, we do not get subverted by monetary concerns above all others. The post holder needs to appreciate that despite the benefits of mediation, the paramount principle is that everyone is always entitled to access the court and to have legal representation in doing so. Thank you.
OK， 多謝阿曼女士。嗱，咁跟
Thank you, Ms. Maureen. Now we ask panel members to give views. First of all, Madam Emily Lau, and then Mr. Yu Si Wing. Thank you, convener. During our discussion on the previous item on the agenda, we talk about the Hong Kong MAL, and no government officials will sit on Hong Kong MAL and it will not benefit from government resources. Now I would like to ask Mr. Arthur Ho, to let us know what is going to be the relationship between this Deputy Principal Government Council and the Hong Kong MAL? It seems that he has a very wide work portfolio, and he is also to participate in supervising the rolling out of qualification for mediators in Hong Kong, and also to take reference from overseas experiences, and also to do publicity and education, all in conjunction with Hong Kong MAL. So he's got a very substantial work portfolio. I'd like to know how is he going to interact with the Hong Kong MAL. Convener, the Hong Kong MAL is not a statutory body, and it is a private body, and the government will not appoint anybody to sit on the Hong Kong MAL. And it is a body representing the industry. And of course, there are many important organizations supporting its establishment and operation. And we hope that the private bodies behind the Hong Kong MAL can really think through what should be the appropriate level of qualifications for mediators in Hong Kong. And also, there are many organizations in Hong Kong that are responsible for training and for accrediting the qualification of mediators, and there are many incumbent mediators that are in the industry. And so the important thing is where to draw the line to make sure that mediators in Hong Kong are at and above a certain standard that is commensurate to Hong Kong's requirements. And also, how can it be ensured that there are sufficient mediators in Hong Kong to make sure that mediation service in Hong Kong is sufficiently price competitive and offers sufficiently wide choices. And the Deputy Principal Government Council will have to work very closely with Hong Kong MAL, because all these issues the government recognizes as very important. And the government is really committed to rolling out mediation service better and more efficiently, and to work very closely with the industry. So even though Hong Kong MAL is a private body with no government officials sitting on it, still there is a lot of room for cooperation between the government and the Hong Kong MAL. Now I'd like to know whether the Deputy Principal Government Council, as created, is going to sit on the Hong Kong MAL or will sit in at Hong Kong MAL meetings. This post is a civil service post within the Department of Justice, and so this colleague is not going to be a regular member of the Hong Kong MAL. But that said, the Deputy Principal Government Council is going to give a lot of views on qualification of mediators, and we have to work very closely with the Hong Kong MAL in many areas. That is why, for the Deputy Principal Government Council, he will have to also work very closely with the Hong Kong MAL, as he has to with Law Society and Barristers Association. Now, obviously, the Hong Kong Law Society welcomes the creation of this post, and I think the other stakeholders also are supportive. And so if this post is created, I'm sure all these stakeholders are going to be willing to work very closely with this new person. The government will be in very close touch with the Hong Kong MAL. As I said, there are 4 founding members, including Law Society, Barristers Association, Hong Kong Arbitration Center, and also Hong Kong Mediation Council, and so on and so forth. And they are all represented on the steering committee on mediation set up by the government. And so there are 3 working parties under the steering committee, and one of them is specifically responsible for accreditation of qualification of mediators in Hong Kong. And so definitely it will have to work very closely with the Hong Kong MAL, and the Deputy Principal Government Council is going to be one of the important channels for such communication. Mr. Yu Si-wing. Concerning paragraph 28 about financial responsibility, concerning the creation of a Deputy Principal Government Council, and also the creation of posts of senior government lawyers, and also a Grade 1 PS post. I'd like to know, apart from the creation of these 3 new posts, Do you need to create any further new posts? And also, your report is a little bit vague. It seems that the Principal Government Council is going to be given an annual salary of $1.6 million, and yet the annual expenditure is going to be $2.3 million. And so it doesn't add up. Does it mean that the Principal Government Council will cost $2.3 million and the other two posts will cost $2.7 million annually?
Concerning those other posts, well, we always bear in mind to economize on resources. So we would only create 3 more posts in the coming 2 years. At this stage, there's no plan to create more posts on top of that. In paragraph 28, we set out the financial implications. But this is standard civil service figures. For the Deputy Principal Government Council, the annual salary is $1.69 million, but to the government, other costs are also incurred. The total cost is $2.38 million for this creation of posts. As for the two other posts, there's another figure. Annual salary $1.46 million. For the 2 senior government council posts, the total cost to the government is $2.17 million. So the total cost for these 3 posts will be $2.38 million plus $2.17 million. Well, if the workload is heavy and you need to create more posts, are you going to report back to us, or can you just do it on your own? Well, we'll follow the established procedure. If the panel doesn't oppose to the proposal, we'll proceed to the establishment subcommittee for the creation of this directorate post. And also, in the next financial year, we'll have to come up with a budget estimate to be incorporated into the total budget. And we'll follow the normal budgetary procedure, and a relevant paper will be submitted to this council. I have 2 questions concerning this post. And that is, for the first question is, why do you have to have someone at the DL2, the second point on the Directorate legal pay scale? And also, how is this post holder going to report to this panel over mediation service? Mr. Ho. Well, we have carefully considered the rank of the new post. We have considered the duties to be carried out, which are rather complicated. For example, assessment or accreditation of qualification. On the one hand, we may want to go for good qualifications, but on the other, they are serving mediators, and we have to make sure that they would be given some room to offer their service. And also, in terms of the law, that we have to look at whether there are certain requirements which would involve careful considerations of complicated factors. So therefore, we believe the rank should be a Deputy Principal Government Council, so as to be appropriately senior for the purpose of formulating policies. As for reporting the progress to this panel, since mediation is important, I believe whenever we have made progress, we will be very willing to come back to the brief members. And then at the time, you know how the new post holder of this DPCC is doing at the time. So we've raised some concerns and we would like to have those concerns followed up by this new DPGC. We mentioned things such as a more inclusive approach, and also the need to have a regular progress report. If no other members would like to speak on this item, I will have to put this question to members. Do we agree that the government should submit this proposal on creation of a supernumerary post to the establishment subcommittee? Do we have any objection? If there's no objection, then you can take it that the panel agrees that the DOJ can submit this proposal to the ESC. Thank you for coming to this meeting. If there's nothing under AOB, then meeting's adjourned. Thank you.